This is a mandated training, and so please listen, and you're responsible for the information. It's all really important. And Allison.
Thank you. Can everyone hear me okay? Great. Just gonna move this guy over here. Good morning, everyone. Thanks for having me. I'm here today to talk to you about the workplace harassment, and New York State requires annual training with regards to sexual harassment and other types of workplace harassment. I apologize in advance because it's not a fun topic to talk about. But this is the mandatory training. It is required, so the content can be a little bit dry. So it's, but some of you have actually gone through some of this before, but this is actually a new training mandated by the state, so it will be a little bit different than past years, so at least there's something. So today's goals, though, what we're going to be talking about is have an understanding of what workplace harassment is, sexual harassment, and that, and how to report, whether it's externally or internally. We will be going through a bunch of case studies, so I hope to get a little bit of participation in this. Actually, I'm going to expect it, because that's less I have to hear myself talk. So we start with identifying what is sexual harassment. Well, sexual harassment is a form of gender discrimination. Oftentimes when we hear the term sexual harassment, we think of it in the asking someone out over and over again, groping and propositioning someone. That is oftentimes what we think about. But sexual harassment covers a wide variety of conduct. It covers taking adverse action against someone because they are in a specific group. Whether it is their gender identity, whether it is because of their sex, whether it's because their status is transgender. So it doesn't just encompass that sexual term, what we think of in that. But understanding, and I'm going to repeat this over and over again, is that sexual harassment is a legal term. Understanding that the conduct leading up to it doesn't have to meet the legal standard for it to be prohibited. It is prohibited. The conduct associated with it is prohibited, regardless of it meeting the legal standard. That is important for you to know because it's the focus on the conduct, not the legal definition. So I want to talk to you a little bit about gender identity. This is a topic we are hearing more and more about lately. And I'm not going to get into it with you with regards to the requirements for students. I'm really focusing on it with the requirements for employee relationships. But part of your understanding of prohibiting discrimination is, and for purposes of your understanding, is to have that understanding of the terminology. Starting with, what is a cisgender? Cisgender is someone who identifies as the same gender that they are born. Transgender is identifying differently than their born sex, and non-binary is they don't identify exclusively as a man or a woman. So, what does harassment look like? It is unwelcome conduct, either of a sexual nature or which is directed at an individual because of that individual's gender identity. So I want to focus on it's the unwelcome conduct because of sexual nature because of their gender identity. And when it has the purpose or effect of the purpose of the effect of behavior interferes with an individual's performance or creates a hostile work environment. This is what you all probably know as hostile work environment. This is what we see most commonly. It is that kind of repeated behavior. It is that kind of atmosphere of that discriminatory, toxic environment. But it's because of that person's gender. But understanding it can also apply to other protected class statuses, such as race, religion, age, disability. It cuts across all spectrums. This is what, even though we're focusing really a lot on the sexual component to it, it does cross other bounds. Employment depends on accepting the unwelcome behavior. This is a tangible employment action. Tangible employment action means that it cannot be done. It cannot be by a colleague. It has to be by someone in a position of authority that has the ability to make decisions as to your employment status. And the last one is what's known as quid pro quo. That is, if you do this, I will do that. Getting something for giving something. So in 2019, the law changed with what is considered harassment. The standard used to be severe or pervasive. What is considered harassment now is more than petty slights or trivial inconveniences. So this standard has been the standard in New York City for over a decade. And so there haven't, because this is a fairly new standard, the rest of the state, there hasn't been a lot of cases on this. But looking at New York City cases, one court specifically said that a singular comment taken together with all of the circumstances can be sufficient to cause a hostile work environment. Now, doesn't necessarily mean one single comment will be. It means one single comment can be in the entirety, taking a look at everything. But as I said before, just because it may not rise to the level of a legal harassment situation doesn't mean it's allowed. And that doesn't mean the BOCES can't take steps to address it either. Another important piece to this is your intent does not matter. I do a ton of investigations all over, and one of the common things I hear is, I was just joking. I didn't mean anything by it. I did not mean that to hurt anyone's feelings. Guess what? That does not matter. It is, you are in a workplace. There's an expected code of conduct that the law says you must engage in. And the law says that that behavior is not okay. It's not your intent, it's the behavior. Now you can agree with it, not agree with it, it doesn't matter, because all we're looking at is your behavior in the situation. And the effect on the other employees. So we have our first case study. June started a new job at a restaurant 3 months ago, and she is slowly getting to know her coworkers. While sharing a meal before the dinner rush, her manager, John, asks her if she has a boyfriend. June tells John that she would prefer not to talk about her personal life at work. He nods and changes the subject. So, the one question, do we think it's that it constitutes sexual harassment? Okay, so I hear mostly no's. There we go. The mostly no's are correct, and that that would be deemed, it doesn't rise to a level of more than a trivial inconvenience or a petty slight. If there were more facts associated with that situation, it could be. But the facts presented to you alone basically says this isn't enough. That isn't going to be enough to satisfy that burden. So, but the conversation continues. In the week that followed, John, whenever he's near June, he complains about how hard it is to find a date, discusses his past romantic relationships in detail, and asks June's advice on how to flirt with other women, often pointing out specific candidates. June repeatedly reminds John she would prefer not to talk about personal lives at work, but he ignores her and continues to make unwelcome comments. June finds herself avoiding him whenever she can. True or false? John's behavior has escalated above a trivial inconvenience to sexual harassment. Good. So, you are all correct there, that it took it to that next level. It went beyond beyond petty slights or trivial inconveniences. She specifically told John that she didn't want that. She specifically told John she didn't want to talk about her personal life and dating. Now understand, you are not required to tell someone that. She happened to hear, but that is not required in a workplace for you to tell someone this conduct is not okay. So what is a hostile environment? It can come in so many forms. It is jokes. That's actually where I see it the most, is the sexual jokes. We work together for substantial amounts of time during our day. We spend oftentimes more time here than any other place, and you get to let your guards down with respect to how you communicate with people. You become friends. So it's natural to speak a little bit more freely, but understanding that you are still in a work environment and that communication is not allowed in the work environment. Now, you could be making jokes between someone that you have that relationship with, but another person could be walking by and hear those comments. You are not alone in here. You are never alone in the workplace, and if everything that is said, someone else can hear. So that's another one I've seen before. This was an interesting one. Was an individual hanging a picture of a scantily clad woman, and the employee was like, "Oh, but that's my wife," and hanging up for everybody to see. But that was not okay, because it is still a work environment. There are still expectations of code of conduct for purposes of what is allowed in the work environment. Now, it doesn't mean his conduct rose to that level of harassment, but it doesn't mean it's allowed behavior either. So the second case study, Whitney is a paralegal at a large law firm that has adopted remote work as the primary way most employees work. As the firm transitioned to remote work, there were growing pains, and for a period of time, employees relied on their personal phones and email accounts to stay in touch while working from home. Though employees now have access to their work emails and phone numbers, on occasion, a lawyer Whitney works with closely, Xander, will text her on her personal cell phone. One night, Xander texts Whitney a sexually explicit image. Exactly. True or false? Xander sent the image from his personal phone to Whitney so that it was not workplace harassment. Good. Though the incident did not happen in the workplace, harassment can occur wherever and whenever work takes place. Employee behaviors outside of work hours that might impact the workplace are covered under policy. In this instance, though the photo was sent outside of work hours, it might impact Whitney's relationship with Xander at work. Xander's behavior is covered by the sexual harassment prevention policy. So, understanding that relationships and things you say and do outside of the workplace can still have an impact in the workplace. So it is important to not send such pictures to your colleagues. Just don't do it. There we are. Oh. All right, the next day, after she did not respond, Xander sends Whitney a text apologizing for the night before and states that the image was meant for someone else. A few weeks later, during a one-on-one meeting discussing a case over Zoom, Xander comments on the fact that Whitney's home workstation is set up in her bedroom and jokes that he would love a virtual tour of where the magic happens. Total X factor. Uncomfortable, Whitney finds an excuse to end the meeting quickly after that. Later that same day, Xander sends Whitney a direct message during an all-firm Zoom meeting telling her he can't stop thinking about her in the bedroom during the workday. True or false, a hostile work environment cannot exist while working from home. Kind of obvious, right? All right, it is false. It is where you're performing work activities. So I think you guys nailed that one on the head. Don't need to read that. All right, next case study. Working twice as hard. So, here we go. Sandra is a first-year resident intern at a teaching hospital in Buffalo. She is the only Black woman in her intern class. She and intern peers attend rounds every day with Dr. Gray. When asking interns questions, Sandra feels as though Dr. Gray holds her to a higher standard than other interns. He frequently makes comments about her ignorance and belittles her answers to his questions, though her responses are in line with fellow residents. One day, as they were walking between patient rooms, Sandra hears Dr. Gray to tell a fellow intern that Sandra must have been a diversity hire. Sandra follows Justin's advice. Did I skip too far? Nope, I'm good. Sandra follows Justin's advice and does not make a formal complaint. As the months go by, Dr. Gray continues to bully Sandra during rounds, including rolling his eyes when she speaks and reacting dramatically when she gives wrong or incomplete answers, behavior that he doesn't exhibit toward any other of her fellow residents, and that embarrasses her in front of colleagues and patients. Recently, his comments have started to venture away from her medical knowledge. Dr. Gray has begun commenting that Sandra needs to make more of an effort in her appearance if she wants to be respected as a professional, including wearing makeup and straightening her natural hair. When Sandra complains to her fellow intern, Monica, who is white, Monica shrugs Sandra's concerns because Dr. Gray has never made her feel uncomfortable with personal remarks. True or false? Dr. Gray's conduct is likely racial discrimination. True. So a couple of years ago now, the state enacted what's called the Brown Act. It's really to address racial discrimination based on someone's hair and headwear. That you cannot discriminate against someone under that purpose because it is a form of racial or potentially religious discrimination. And as you can see, this scenario that there were overtones, there was discussion about her gender, but also race. So meaning that it can be more than one. So, and I do want to hit on something here about bullying. It does talk about being bullied. And that is, bullying alone is not a basis for harassment discrimination. That, we have DASA. DASA prohibits bullying, but that's against students. The standard for workplace harassment is a little different, and that bullying standard does not exist. It's bullying plus something. It's bullying because of someone's status in a protected class, not just being a jerk to someone else. You know, it doesn't mean that that's okay, but it doesn't mean it's harassment either. So, Dr. Gray's conduct is likely sexual harassment. True or false? Hey, you guys are fading out on me. Come on. There we go. All right, true. Again, even if other women in her intern class feel respected, Sandra has experienced belittling behavior and remarks regarding her appearance that appear to be discriminatory based on her gender. This behavior likely meets the legal standard for New York for harassment as it rises above petty slights or trivial inconveniences. Quid pro quo. So this used to be the only standard for sexual harassment years and years ago. It was based on that, you know, you'll have a promotion, a raise, if you engage in sexual activities with a supervisor, or, but it's also the flip side of if you don't do this, you'll get fired. This is what is known as quid pro quo, but it is required. It can only happen when it's someone in a position of authority, because they're the only ones that have that ability to make decisions to impact your position in an organization. It does still happen, but it's not something that is as common these days as it used to be, thankfully. So, but shaken, not stirred, case study number 4. Jamila is a bartender at a popular Brooklyn restaurant. She has been with the restaurant for a month and is hoping to be scheduled during the popular Friday and Saturday evening shifts. Her manager, Jason, creates the shift schedule. She tells him she feels confident in her position and that she knows the restaurant patrons well enough to be scheduled for the high-tipping weekend shifts. He tells her, "We'll see, we have a lot of qualified bartenders." It's delaying. So, a week later, Jamila and Jason are closing after a Wednesday night shift. Jason pours them both a shot of tequila, asks Jamila to join him at the bar, and tells her that he hopes he'll be able to give her some weekend shifts. He tells her that some other bartenders have been with the restaurant longer, but she is the one he wants. Jason places his hand on Jamila's knee and encourages her to drink the tequila. Jamila quickly takes the shot before jumping off the bar stool and finishing her closing tasks. True or false? Jason's behavior could be harassment of Jamila. True. There we go. Jason's behavior as Jamila's boss is inappropriate, and Jamila should feel free to report behavior that made her feel uncomfortable. Jason's behavior at this point may or may not constitute quid pro quo. Jason has made no promise or threat to Jamila that he will handle her shift schedule differently based on how she responds to his advances. So there's definitely innuendo there, but it's not definitive. Every situation is going to be a little bit different. You can't, these situations are not viewed in isolation and the same, because no two situations are the same. But again, even if it doesn't rise to the level of harassment, it's still conduct that should be reported. It's still conduct that can be addressed, because it is not appropriate behavior. Yeah?
What if, say, it's a small restaurant, there's no human resource department, or it is your NYS manager doing this, above them, who you go to?
Oh, well, that's going to be one of my slides coming up, but I'll hit it right now. So there is other resources you can report externally. There's the New York State Division of Human Rights and the EEOC. The Division of Human Rights is state, and that applies the petty, slights, or trivial inconveniences standard. And the EEOC is the federal organization that you can report to, if that's, in that situation as well. So, or you can, if someone feels comfortable enough, which I understand if they don't, you can tell that person, stop. I get that's a difficult situation and no one has to do that, but if you feel comfortable doing it, you can. But great question. However, his discussion of shifts while making what could be seen as a sexual advance is inappropriate. It might be considered potentially coercive. If Jason continues to make advances, even if he never makes or carries out any threat or promise about job benefits, this could create a hostile work and hostile environment for Jamila, for which the restaurant owner could be strictly liable because Jason is a supervisor. After a week of continuing to receive less desirable shifts, Jamila asked Jason if he would schedule her for a Friday or Saturday night. He says that he is not sure, but while there is still time for her to make it worth his while. He then asks her to come home with him after work that night. Yeah, again, So Jamila, who really needs the extra cash of a Saturday night shift, will bring the Saturday night shift will bring in tips, decides to go home with Jason. Almost every week, they go out at Jason's insistence and engage in sexual activity. Jason begins scheduling Jamila for Friday and Saturday evenings. Jamila does not want to be in a relationship with Jason, is only going out with him because she believes that he will change her schedule away from the busier shifts. True or false? Jamila cannot complain of harassment because she voluntarily engaged in sexual activity with Jason. Good. So one of the big key things there is that position of power, that power differential in that kind of situation. Because he has the ability to impact her employment, how much she makes. But the other thing is, if she just because he didn't make any threats or she didn't, he doesn't even have to overtly say these things. It can be based on the total circumstances. So, but the process, what happened was basically is this quid pro quo of she gave him sexual favors for better shifts. And that's not permissible to do that. Regardless of, and even if she didn't agree to it, it's still not allowed. And even if he gave her the shifts, that his behavior is still not allowed. It's the focus of what is his behavior. And can Jamila complain of harassment if she got the shifts she wanted? Yes, she can, because even if she receives a benefit, because it's not a real consent situation. This is someone in a position of power that is using their position to get sexual favors. So after several months, during which she believes she has proven herself as an asset during the weekend rush, Jamila breaks off the sexual activities with Jason. He immediately changes her schedule, and places her in less desirable shifts with fewer customers and lower tips. True or false? It is now too late for Jamila to complain. Her relationship with Jason was consensual, so there is no proof she is receiving less favorable shifts due to the breakup. Good. False. Jason's conduct constitutes quid pro quo sexual harassment, whether or not Jamila accepts the benefits or rejects them. Sex stereotyping is gender discrimination. So sex stereotyping is really about not placing people in boxes because of their gender. It is, sex stereotyping, it would be that only, that men are not allowed to wear dresses. Right? That is something we are seeing more and more these days. And you cannot discriminate against someone because of a man wearing a dress. Or you cannot discriminate against someone because a woman may not want children. We are all different. None of us, no man or woman, fits into a particular mold and of what, what to do, what to wear, what to say. And so this is something that there is a greater focus on by the State Division of Human Rights, and is what is expected for you in the work environment. So, which of the following examples are sex stereotyping? Amy is a steel worker with 25 years of experience. Her supervisor, Gus, always assigns a male coworker to partner with Amy on any project she is assigned. Similar projects he assigns to Amy's male coworkers to accomplish solo. When Amy confronts Gus, he explains that he wants her to be safe as she is the only woman on a tough job. Well, we'll just go one by one since we're on different slides. Is this sex stereotyping?
Yes.
Why? Like she can't handle herself, right? He's implying she can't handle herself. So, Frank is an administrative assistant at a popular production company. He applies for an internal promotion to serve as administrative assistant to the company's executive director, which will involve greeting several high-level guests when they come to meet the director. Frank is gender fluid and wears makeup and dresses on occasion. Though more qualified than other candidates, Frank does not receive the promotion. The executive director explains that while he supports Frank's lifestyle, many of his guests are more traditional and would not be comfortable with Frank as their point of contact. Is this sex stereotyping? Yes. A finance firm hosts regular quarterly luncheons for their most important clients. At every luncheon, the CEO, Peter, directs all his questions regarding logistics of the lunch to Susan, the vice president Peter works with, and only woman in leadership, the only woman in leadership position at the firm, despite that Ronald, the organizer of the lunches, is also in the room. So, what, sex stereotyping? Why? Yeah, she's the only female, and it's presumed she does the ordering, handling all of those logistical matters. So, number 4, George is the primary caregiver for his young son as he works from home for a tech company while his wife goes to the office. George's toddler has been known to interrupt video meetings, but George's output is impeccable. Still, George is often left out of meetings because his boss does not want to deal with Mr. Mom. Sex stereotyping? Yes. All right, well, they all are. These are just intended to give you examples of, as to whether these are, what sex stereotyping is. So, who can be the target of sexual harassment? This has developed and changed over the years. We talk about workplace harassment in the way that the purpose of it is to protect people from discrimination or being treated adversely because of a characteristic that they cannot change. Whether it is your age, disability, race, sex, gender, all of that's what's intended to be. And people shouldn't be penalized in the workplace because of that. So for a long time, the law only protected paid employees in the workplace. And so, but that has developed over time. It now covers interns, which it didn't before. But it also covers independent contractors and vendors. So I could be here and I could be subject to workplace harassment. Because I'm here in my work, my capacity as a lawyer, providing services to the BOCES, and I could be subject to sexual harassment. I was doing an investigation one time, and one of my witnesses who I was interviewing, first when I met him, first then calls me young lady, and then when I was about shaking his hand, he took my hand and attempted to kiss it. That is true. It just happened a few months ago. I'm like, please don't do that. Please don't do that. And he goes, well, I was brought up right. That was because in his mind, he was being a gentleman, not understanding it is highly inappropriate for the workplace. So yes. And did I sue my own client? No. No, but my point was anybody can be. And it doesn't mean you have the right to sue anyways. I was just kidding. It's that's a whole other conversation. But it doesn't mean it's okay. So who can be the perpetrator? Well, just like I can be the victim, I can also be the perpetrator. So I cannot come in and kiss someone's hand because that would be inappropriate for the workplace. So, so it's not just about your colleagues, your supervisors, but you do not have to be subject to sexual harassment in the workplace, even if it is by someone else. And if you feel like that is happening to you, you need to report it right away. Just can't do anything unless we know about it, right? Which we'll hit on in a little bit. So where can it occur? Well, we hit this one pretty well. We know it can happen remotely. We know it can happen in the cafeteria here. We know it can happen at conferences. It can happen at office parties. It can happen online. It's basically whenever and wherever employees are fulfilling their work responsibilities. Now, just because you may not be fulfilling your work responsibilities, understanding that what you do can still have an impact in the work environment. So even though it could be totally off school hours, totally separate and distinct, that has nothing to do with your work responsibilities, you still have to work with these people. You still have to come in. So your behaviors outside the workplace can still have an impact in when you are on duty. Just as we noticed like Whitney and Xavier with the lovely picture. So, okay. So, which scenario might an employee claim harassment or discrimination? A patient harasses his at-home caregiver. A customer asks a waitress to remove her mask so he can decide how much to tip. Yeah, that's awesome. An employee frequently comments with discriminatory language on a coworker's social media post. An employee gets handsy with his colleagues at a hotel bar during a conference. Good. So now, doesn't mean every one of these items will necessarily constitute legal workplace harassment, but it also doesn't mean it's allowed behavior. We don't have all the factual circumstances. I mean, we kind of can figure out that it does. A lot of these would likely, but it doesn't necessarily. Like number 3, that has, that might be not constitute workplace harassment. But it is still behavior that could impact the work environment. So these are situations where you might file a claim of workplace harassment. Again, doesn't necessarily mean it is. Have some more examples. A copy repair person tells jokes that are degrading towards women while fixing the copier. Cleaners employed by the building and an organization that represents this, rents the space in, and they discuss their sexual prowess loudly. A hotel guest ropes a housekeeper as she walks by. So, do we think all those might constitute harassment, discrimination? Yeah. So, what do we do if you are a witness? That is actually one of the most common questions I get. And now they have actually incorporated this into the mandatory workplace harassment training. So what do we do if you are a witness to harassment? So there's 5 methods of what's called bystander intervention. Interrupt the harassment by engaging with the individual being harassed and distracting them from the harassing behavior. Ask a third party to help intervene in the harassment. Record or take notes on the harassment incident to benefit a future investigation. Check in with the person who has been harassed after the incident, see how they're feeling, let them know the person's behavior was not okay. And confront the harassers and name the behavior as inappropriate only when you feel safe. So these are some options and tools for you if you are seeing it happen. The other thing is you can report it. And you should, and it is encouraged that you do report it. So what method of bystander intervention is this example? Hotel cleaner Frances is walking down an empty hallway between rooms. A guest pushes her up against the wall and attempts to assault her just as hotel bellhop Tony comes out of the elevator. Tony places himself between Frances and the guest and tells the guest he is behaving inappropriately. Do we know which one of the 5? Which one? Yes. Confronting the behavior directly. So, but if you don't feel safe doing that, you don't feel like you have to either. You don't want to put yourself at risk, but understanding there are other tools, such as trying to distract the other person to say, hey, I need your help with something. Could you help, or so-and-so is calling you, the supervisor's calling you. Those are other ways of intervening. Kyle is asking Sheila about her dating life. Sheila says she does not want to talk about it at work, but Kyle keeps asking about it. Taylor asks Sheila to review a slide deck she is working on. Which one? I hear a lot of mumbling, but no real answers.
Distracted.
Yes. Engaging and distracting the person being harassed. So, bartender Leslie notices a restaurant customer is brushing up against his waitress Danielle, touching her arm or leg every time she comes to the table. Leslie tells her supervisor, who intervenes and allows Danielle to switch table assignments. Which bystander intervention is this? Third party. Yes, to help. So, I want to go back to this one. So, this is a big one where, it is not another employee. This is a customer. But once the employer knows about the situation, they should not allow the conduct to continue. So just because it's an outside party doesn't mean it is okay conduct. Retaliation. So, retaliation means that adverse action can't be taken against you because of your involvement in protected activity. Protected activity means making a complaint of harassment, providing information during investigation, and testifying in connection with a complaint. So this is based on involvement in reporting or providing information tied to an investigation. It does not protect individuals who make bad faith claims. I want to repeat that. It does not protect individuals who make bad faith claims. And this is something I've seen more than once. And understanding that if you do make a bad faith claim, that you can be subject to disciplinary actions.
Can you give an example of a bad faith claim?
Lying.
I mean, flat out lying, yes.
Flat out lying.
How about in the gray area? I'm curious.
I mean, a whole scenario. I mean, if what you're reporting you know is not true, is just because you perceive something to be sexual harassment, or you perceive it to be harassment, discrimination, that doesn't make it bad faith. Just because you were wrong in your assessment of it doesn't necessarily.
I guess that's what I'm getting at. Someone might believe they see something, they report it, and now they're the ones, as you said, not protected because
bad faith.
Wasn't.
Yeah. So just because you may have been wrong in the final result doesn't necessarily mean it's bad faith. It means knowing that the conduct is not true and reporting. Yeah.
Thou shalt not bear false witness against thy cohort.
Thank you. So, what is retaliation? It is basically it's any adverse action, changes in employment, conditions of employment because of that person's involvement in the protected activity. It could be a reduction in title. It could be getting terminated. There are it's any change of employment. That's kind of similar to your tangible employment action. But what it's not, so this is something I see on a regular basis, is I'm investigating someone for misconduct, and they get wind of this misconduct, so they decide to throw in a claim of harassment based on, sex, based on any sort of protected class. It doesn't mean it is a shield for the BOCES not to take adverse action, because it is based on the misconduct. It doesn't provide a shield. And I see this all the time, that it's I'll go on that offensive because I might get in trouble. So you're not protected by retaliation if the employer is addressing poor performance or bad behavior. It is not, and that protection doesn't mean it carries on forever. It just means it can carry on forever in the fact that if that adverse action is taken against you because of your involvement in a protected activity. That's it. It's not a shield forever for all sorts of conduct. So, case study number 5. Maria is a domestic worker hired as a nanny by Dan and Lisa. One day, while helping their daughter, Jovi, clean up her toys, Maria enters the hallway just as Dan is emerging from the bathroom. Having just showered, Dan is wearing only a towel. Flustered and embarrassed, Dan apologizes and runs to the bedroom to get dressed. True or false? Dan appearing in only a towel is harassment. False. Good. False. The interaction was accidental. He did not engage in any intentional activity. Now, I say intentional activity. So I said earlier, not intent. There was no intent. Well, so there's a difference between not intending to hurt someone or not intending the words to mean something negative. And there's a difference between actually intending to say them. In this situation, he did not intend the interaction to occur at all. But in the situations of the inappropriate jokes, the person, I say you loosely, the person who made the comments didn't mean them to, as to what they didn't mean the meaning, the underlying meaning. Big difference. So keeping in mind, this is an accident, the other ones is the intent behind the comments. So Maria focuses on caring for Jovi, and after some initial awkwardness, she and Dan have a professional, if distant, relationship. Lisa serves as the primary employer overseeing Maria's schedule and paychecks. Though not typically scheduled for the weekends, Maria agrees to work overtime to help Dan while Lisa is on business one weekend. Without Lisa home, Dan sits and stands very close to Maria, frequently brushing up against her, and at one point patting her butt.
There it goes.
Yep. So is this, as a domestic worker, is Maria protected against sexual harassment? Yes. All employers in New York State, regardless of size, including households employing a single domestic worker, are required to adopt a sexual harassment policy. Maria is covered by the state's human rights law against sexual harassment and discrimination. If Maria feels safe, she can report the incident to her employer, Lisa. If she does not trust Lisa to act, she can file a complaint with the New York State Division of Human Rights. So when Lisa returns, Maria reports Dan's inappropriate behavior to Lisa. Maria cares for Jovi and Lisa and wants to keep her job, but she tells Lisa she does not feel safe being left alone with Dan. Lisa tells Maria she appreciates her honesty. That evening, Lisa writes a post online on her online neighborhood mom group, warning families not to hire Maria because she is bad at her job and will try to seduce their husbands. Lovely. True or false? Lisa did not fire Maria, so her online post is not retaliation. False. Harassment and retaliation do not need to happen in the workplace. Such a post will make it very difficult for Maria to find a new job should Lisa decide to fire her, or should Maria decide working for Dan is no longer possible. This punishes Maria for coming forward with Dan's harassment and leaves her in a position of weakness. So supervisor responsibilities. Supervisors and managers, administrators, they're held to a higher standard of behavior and reporting requirements. Supervisors are required to report any harassment that is reported to them or that they observe. Now, I want to clarify what this means, because one of the things I frequently see and hear is, oh, don't worry, I will keep it confidential, or or the employee comes in and says, I don't want anybody to know about it, don't do anything about it. That is not permissible. The supervisor, the administrator must report it. They must report it to Jen DeFrank. So that is a requirement. So it doesn't matter, if you report it, it has to be taken to the next level. It is not one of those things, I'm just venting, I don't want anything to happen. Because here's the thing, it's not okay if it's happening, so something has to be done about it. And the way something is done about it is that it's reported and goes through the appropriate channels. So, and we can't do anything unless we know about it. So the other pieces to supervisors and managers is that they're responsible for harassment or discrimination they should have known about, and expected to model appropriate behavior. So those But that mandatory reporting piece is important. No matter how much you say, I don't want anything done. There is, in these kinds of complaints, they're kept confidential to the extent possible. There has to be some disclosure as one for purposes of reporting as required, but also to conduct an investigation. There's never full confidentiality in these circumstances, and actually in almost all circumstances. Full confidentiality does not exist in any situation. I mean, even with FERPA, you have the million exceptions under FERPA, right? So the confidentiality is confidential to the extent possible. Hello? So, call me by my name. Erin is a trans woman who works at a marketing firm. She has been with the company for 20 years and has come out and transitioned with the company over the past 7 years. At this point, all her coworkers know her as Erin and her preferred pronouns of she, her, hers. Though she has support from leadership and the majority of her coworkers, Erin's colleague, Vanessa, continues to refer to Erin by the name she received at birth and no longer uses, otherwise known as dead naming, while she also continuing to use he, him pronouns. When Erin asked Vanessa to stop, Vanessa stated being transgender violated her religious beliefs. Erin reported the treatment to her supervisor, Jessica. Jessica sympathized with Erin, but advised her to just let it go because Vanessa would be retiring soon. True or false, Erin can file a complaint against Vanessa and Jessica for gender discrimination. True. As a supervisor, Jessica is required to report any claim of gender discrimination. By telling Erin to ignore this behavior, Jessica is not fulfilling the responsibilities of a manager. Vanessa also does not have the right to intentionally ignore preferred names and pronouns. Under the New York human rights law, personal religious belief is not a justifiable defense for discrimination. Erin can file a claim of potential gender discrimination by both Vanessa and Jessica to her company's HR department or the New York State Division of Human Rights. So, as I said before, there's been a lot of changes to the New York State Division of Human Rights. One of the changes specifically states intentional refusal to call someone by their preferred name and pronouns is discrimination under the law. It is specifically enumerated. Doesn't matter what your beliefs are. So now we're on to what should I do if I am harassed? So first thing is report it. It's not okay. You do not have to wait for it to rise to the level of legal harassment for you to report it. In fact, it's preferable that you report it earlier so we can stop it earlier. Because we can't do anything unless we know about it. So first thing is report it. And the next what happens is, first you can report to a supervisor who would then report it to Gender Frank, or you can report to Gender Frank directly. From there, what happens is an investigation will commence. The other piece to it is you do not have to write a written complaint. It is recommended you do. It's helpful, but it is not required. So even if you don't submit a written complaint, steps will still need to be taken to address it. It is still considered a complaint, regardless of if it's in writing or not. If you are not a supervisor, but you become aware of it, there's not a requirement that you report, but you should report. Because again, we can't do anything unless we know about it. And we don't want people in the workplace to be subjected to those behaviors that we've talked about. That's not okay behavior. So it is important to report it. So what happens when you report it? Usually what happens is, well, what can happen is an employee can be placed on paid administrative leave during the course of an investigation. Doesn't always happen that way, but it can be done that way. So from there, what happens is an investigation will commence, and that includes interviewing all potential witnesses and the complainant. The complainant is not always the victim. The complainant is who reports it. The victim could be someone different. So interviewing the complainant, the victim, all potential witnesses, and the accused person. So during that investigation, it's intended to be confidential to the extent possible. I do a lot of investigations. I cannot go in and just stare at someone hoping they're going to tell me what I need to know. It doesn't work that way. So I have to disclose certain information to get information. And that person might end up, it is likely that person will end up knowing you are the complainant. It's unfortunate. But we can't deal with behavior unless we know about it. The other piece is retaliation is prohibited, as we talked about. So if you make a complaint and adverse action is taken against you because of that complaint, you need to report it. You need to tell someone. There are protections for people in place who make complaints, but we can't do anything unless we know about it. We went through all those. So, another case study, banking on you. Sawyer is a manager at a mid-sized bank. Sawyer recently began dating Hayden, a bank teller at the bank. After 3 months of dating, Hayden breaks up with Sawyer. Though the two agree to act professionally at work, Sawyer takes the breakup hard. As manager, Sawyer is sure to assign Hayden shifts so they are always at the bank at the same time. Sawyer creates special projects to work one-on-one with Hayden, ensuring that you are alone together at the bank. More than once, Sawyer uses these sessions to urge Hayden to give their relationship another chance. Hayden is firm that their romantic relationship is over. True or false? This is not sexual harassment because Sawyer and Hayden were in a consensual relationship, and Sawyer's behavior is typical of anyone dealing with a hard breakup. Aww, it's so sad. So, no, it's not okay. Not okay. Just because you had a prior relationship does not mean that behavior is okay. And it doesn't matter how heartbroken you are, you can't act that way in the workplace. So, and it doesn't matter that their prior relationship was consensual. Did I hear someone? Oh, kitchen, okay. Just want to make sure I didn't miss a question. So, frustrated that Hayden will not consider their relationship, Sawyer begins complaining to coworkers about Hayden's perceived cruelty. While complaining, Sawyer frequently divulges personal information about their romantic relationship and Hayden's private life. True or false? This is a personal issue between Sawyer and Hayden, and coworkers should not get involved. I think that question, that true false, is kind of worded terribly. That's how it's worded by the state. I took that mean, yeah, it is no one else's business what happened between them. But the way it is intended is that employees have the right to report. It has to do with other employees reporting the conduct, not the other side. I thought when I read it, I was like, no, of course it's personal. No one has the right to know that information. But it is intended about the reporting piece. So just because you are not involved in the matter, if you are a witness to it, if you are hearing inappropriate things, you have the right to report those things, and should. It is encouraged because this is still a workplace. So, alternative options for reporting. You have the right to report to the Division of Human Rights. That is a complaint that is through the state. You also have the right to report, file a summons and complaint directly with the state court. There's a 3-year statute of limitations. You do not need an attorney for filing with the State Division of Human Rights. There is information with regards to a hotline called This Is New to the State that is available. It's also on the state website. The EEOC, you can file a complaint within 300 days. This is the federal route. Again, do not need an attorney, but to file a lawsuit against an employer, you must file with the EEOC first. It is exhausting your administrative remedies. And more information on the website. So, also keeping in mind, some conduct can be criminal. A sexual assault could be both criminal and deemed sexual harassment in the workplace. You may contact law enforcement. Now, understanding, there's a charge called harassment. There's the penal law definitions are often different than what the employment law definitions are. But understanding that doesn't, they may see something differently as not a crime, but you still have that avenue of reporting. So, no go Joe. That's a tongue twister. Mallory works at a small family-owned gift shop. She is one of 2 employees in addition to the owner, Joe. The storage room at the back of the shop is tight and can sometimes require Mallory and Joe to get very close while restocking inventory. On more than one occasion, Joe has brushed up against Mallory while moving past her. Though she initially thought it was unintentional, Joe is now pressing himself against her in a clearly intentional way. Mallory mentions this to her coworker Emily, who confides that Joe has been doing the same to her. Joe is both the owner of the store and Mallory's supervisor. There is no separate individual at the store through which Mallory can make a harassment complaint. True or false? Mallory's only option is to confront Joe directly about his behavior by writing a report and submitting it to Joe. Good. False. She feels safe, she can complain to him directly, but she doesn't have to. She can file a complaint with the State Division of Human Rights or the EEOC. Other types of workplace harassment. So yes, our focus really has been on sexual harassment because that's what's required by the state. All of these laws, all of these examples also translate to the prohibition of discrimination and harassment for other protected categories. That meaning age, race, creed, military status, marital status, domestic violence victim status, gender identity or expression, familial status, criminal history. These are all other bases for discrimination that are prohibited by the state, and some also by the federal government, but not all. But understanding just you can have more than one form of discrimination in the same act as well. So all of these tools that I just talked to you about, all of these examples can still apply. Understanding that the term harassment, the term hostile work environment, which I hear all the time thrown around, it's not just being a jerk to someone. That's not what this is. Harassment, hostile work environment means that it's because the adverse action, being the jerk because of someone's status in a protected class. And that is an important distinction to know. The other piece to it though, keeping in mind that being a jerk doesn't necessarily get you up to the hook for being in trouble. So we can still deal with that, just in a different way. So this is the summary of what we learned today. Any questions that for me that I can answer before we wrap this up? I understand this is dry material. I appreciate your attention, and I hope you have a wonderful school year.
Thank you.